Hello everyone. In today's lesson we're going to be looking at a lot of vocabulary, and we're going to be looking at the way law is classified or characterized. And while this may be boring for some of you, getting these terms under our belt, understanding the differences in these terms, is going to make reading legal cases a lot easier, and it's going to make it a lot easier when you're looking at a possible litigation that your business might be involved in, to understand what the different avenues the law might take as you are working through the process. So, as a general overview, we're going to be looking at three different pairs of types of laws, and those would be substantive versus procedural law, criminal law versus civil law, and civil law versus common law. And there are obviously there's differences to each and every one of these. So let's just get started right now with the differences between substantive and procedural. Substantive law, think of it as the merits of the case, the actual issues involved that are being litigated. Can I get out of this contract? Do I have a right to sue a supplier who didn't deliver on the day he said he was going to, and it cost me money? Does a customer who got sick from food they purchased in my store, do they have a case against me? This is substantive because the court will be looking at the actual merits of the arguments on both sides. The other type of law to contrast that with is called procedural. And very often it is the procedural rules that a case gets decided on. Very often when the Supreme Court issues a ruling, it's not always based on the merits of the case, but on something that happened with the procedure. Procedural law are the rules that get us to the case. So for instance, it might be something like, did you bring your suit in a timely manner? If you are bringing suit against someone for something that happened 10 years ago, but there's a statute of limitations, a law that says you only got 7 years, the case will be decided against you based on procedural grounds. Do you have standing to sue? And by standing means, are you truly an aggrieved party? If I have two neighbors across the street, and one of them is throwing rocks through the other's window, I cannot sue the neighbor who is doing the rock throwing because I don't have standing. I'm not an active party in the case. And in addition to having standing, we have to have a causation issue. And you will read this a lot in cases that we look at where the judges will refer to the word causal, and 9 times out of 10 students read that and they read the word casual. It's just something the mind does. The word is causal or causality. If I am experiencing many more asthma attacks than usual, and I've discovered that 4 states away there's a power plant that's emitting something they didn't emit before this can actually be litigated on the merits, there has to be a sense that there is an actual causation issue between what they did 4 states ago and the issues that I am suffering right now. So you need to have standing. There needs to be a true issue of causality. It needs to be brought timely. You need to bring it in the right place. If I have a store in Greenfield, Massachusetts, and a resident of Greenfield, Massachusetts wants to sue me for something, they can't bring the case, in Oregon because they know it's going to be a pain in the neck for me to get there. You've got to choose the right venue, and venue is the word we use for the place. Did you bring it in the right court, in the right state, in the right location? Did you give notice properly? Someone can't sue your store if they haven't sent the proper notice that you're actually being sued. And they can't just show up in court and you're surprised. And on the flip side of that, if someone doesn't show up to court, well, the case may be dismissed simply not on the merits, not because they're looking at what actually happened, but because the other party didn't show up. So all of these are procedural issues. Sometimes the court will dismiss a case because it's not ripe yet, meaning your business is trying to sue the state for a law that's going to hurt you that they haven't even passed yet. Well, that's not ripe. On the other hand, they may dismiss it because it's moot, meaning you want to sue the state for a law that's going to hurt you, but they withdrew the law. The law no longer exists. So all of these are procedural issues, and very, very often, if a court can adjudicate a case based on a procedural issue rather than a substantive issue, they will. It avoids creating any additional precedent, and we'll be talking about that in a little bit. And it's just, it's the first line of defense for the court. Has all the process been followed correctly? So that's substantive versus procedural. The second division in the law is criminal versus civil. Now, almost all the dramas you watch on TV that are legal dramas, almost all of them involve criminal cases. So you may have a perspective that criminal cases is the norm. In a criminal case, the case is brought by the state or the federal government. It's the district attorney or the attorney general of the state or the U.S. against an individual. In other words, the crime is seen as if it's against the people in general. Okay? So, in that case, there are very, very strict criteria for finding someone guilty. And you're probably all familiar with the term, you must be found guilty beyond a reasonable doubt. And this is where you can have no reasonable doubt on each element of a particular crime. And, of course, one of the reasons for this is that if you are found guilty of a crime, the punishment is going to be, it could be a fine, and it could also be jail time, and you lose your freedom. So everything's got to be done beyond a reasonable doubt. So to give you an example of how this works, New Hampshire has a criminal trespass statute. And it reads, it's very simple. It reads, a person is guilty of criminal trespass if, knowing that he is not licensed or privileged to do so, he enters or remains in any place. It's one sentence. It sounds very simple. In going to court in a criminal trial, each element of that crime must be proved beyond a reasonable doubt. Well, what do I mean by elements? Well, in that simple statement, knowing that he is not licensed or privileged to do so, he enters or remains in any place. You literally have to prove beyond a reasonable doubt that we're talking about A, a physical place, B, that the person entered or remained, C, that they're not licensed or privileged to do so. There's no permission for them to do so. And 4, knowing that that is the case. And they must all be proven beyond a reasonable doubt. So you may be walking through the woods, there's a trail, maybe you saw a trail map, and you're following the trail, it's going through a state park or something, and there's a couple of side trails that go off of it. One of it takes a little loop through the corner of someone's property. Yeah, you were in a place you probably didn't have any permission to be there, but you didn't know you crossed a boundary because there was no trespassing sign. There was no fence. You were following a network of trails. If they cannot prove beyond a reasonable doubt that you knew you were on someone else's property, then the prosecution against you fails because they have to prove that element. This is why, now, in this particular statute, this is why a U.S. Census Bureau worker can walk up to your property and you've got barbed wire and a locked gate and a no trespassing sign. They can still enter. Why? Because the U.S. Congress said census workers have a right to enter properties to obtain the information required in the U.S. Census by the Constitution. Therefore, they are privileged. So a statute that says you can't enter someone else's place if you're not licensed or privileged to do so, they're privileged to do so. There was a court case in Kansas, I believe, where a man owned a liquor store and he was suspected of selling to minors. And he put a sign right on the front of the door, "No one under 21 may enter." Well, the State Liquor Commission got a teenager to work for them, and they did a bit of a sting operation, and that under 21 person went into the man's store and bought liquor. When he was prosecuted, he said that, well, this kid you used is guilty of criminal trespass because he knew he was in a place that he should not be. Of course, he lost that argument because, based on the state liquor authority and the legislation under which they operated, they had the right to use people who were under 21 for these type of sting operations. Therefore, there was a privilege or a license to do so. So each and every element of these crimes has got to be proven beyond a reasonable doubt. And that's something that is most often given to the jury to try and decide. That's criminal law. Civil law is very, very different. It's not the state coming against you and proving its case beyond a reasonable doubt and sending you to jail. It is an individual suing an individual, or a business suing a business, or an individual in a business. If I sue you, I don't have a right to put you in jail. Right? I don't have a jail in my basement that I can lock you up in if I win. In a civil case, the damages are almost always monetary. It's a money judgment. Sometimes, when a money judgment will not work, it's a court injunction, meaning the court says to one of the parties, "Thou shalt stop doing that. You will not do that." In a civil case, we don't normally have all of these elements of a crime that must be proven. Instead, what we need to prove is that someone harmed me. Someone harmed me through being negligent. Someone harmed me through violating contract. It's not proving each and every element. And the standard is a preponderance of the evidence. In other words, if we look at everything about this interaction between these two parties, what seems to be the right answer? Where does 51% of the evidence seem to land? That's all that's needed. And that's why you will often see one person who has engaged in a particular set of actions, and they're actually sued twice. In a murder case, the state will bring a criminal case against the person who committed the murder. The family of the victim may bring a civil case in wrongful death. One sends the murderer to jail, the other usually gets monetary damages. One requires beyond a reasonable doubt. One requires a preponderance, or the majority of the evidence. Very different standards, and you can have two different outcomes because of that. If you are a contractor, all right, let's say you take and you're going to do some work on someone's house, you take half the money because you need to buy your material to do the work you're going to do, and then you skip town and you never show up. The state may prosecute you for fraud or for theft by deception, which some states have that type of a statute. And the homeowner may sue you in a civil suit for restitution of the money that they've already paid you. So, again, one set of facts, one set of circumstances may result in a criminal prosecution as well as a civil prosecution. The last set is civil law versus common law. And I know this is you're going to roll your eyes at this, but when I say civil law versus common law, civil law means an entirely different thing than what we just spoke about in terms of civil law versus criminal law. The word civil law is used in two different ways. It's unfortunate, it's confusing, it's the way it is. When we look at civil law versus common law, civil law nations, which are many nations, in fact probably most nations that did not have some type of British colonial ancestry, is law by statute. Meaning the law says this, then that's simply what we do. It's what a lot of law students would wish was the law. Because when you ask, what's the rule in this case, you want to know what the written rule is. That's civil law. We are not a civil law nation. We are a common law nation. So is Canada, Australia, New Zealand, the United Kingdom. As I said, most nations that have some background with the British legal system somehow are common law nations. And what that means is that the laws tend to be general, and courts make decisions by applying the facts of the case to what law they have, and they make that decision, and once they make that decision, it is called a precedent. There's a doctrine in common law called stare decisis. Stare decisis is Latin, meaning we stand on precedent. So that once a court case is decided on a particular fact pattern, courts down the road will look at that decision to guide their own. And if it's generally the same fact pattern, they're going to rule in the same way. So, give you an example of that. Your neighbor goes away for vacation or something, and you decide to borrow their lawnmower. So you go into the garage, you take their lawnmower, you cut your grass, and the lawnmower breaks. Your neighbor comes back home from vacation, he's upset with you, and he sues you. And the court decides the appropriate remedy is to have you pay for repairs to your neighbor's lawnmower. That now establishes a precedent. Notice this judge did not say you have to buy him a new lawnmower. He said you had to repair the mower that you broke. So now, down the road in the same jurisdiction, a similar thing happens where my neighbor goes away for the week and I really need to get some woodwork done, and he left his shed open and we're on good terms, so I'm going to borrow his chainsaw. So I take the chainsaw, I use it, and I break it. We can't agree on how to resolve it, so he brings suit. what the court will do is say, well, this is a very, very similar situation to what happened in the lawnmower case. Therefore, due to the principle of stare decisis, we stand on precedent. The appropriate remedy would be for me to pay to fix the chainsaw, not to buy him a new one. Now, some time goes by, and Joe decides to borrow Bill's car. Bill went away on vacation. He left his car in the driveway with the keys in it, and Joe borrows Bill's car, crashes it. When this gets to court, a court may decide, that this is similar to the lawnmower and the chainsaw, and therefore you should pay for repairs. On the other hand, there may be additional facts involved here, such as perhaps the car is used for work, and he needs the car for work, and he'll be out of work and he's going to lose income as a result of the car being damaged, and the time it takes to fix that car is going to impact him. There may be some differences here, and this judge may distinguish the case. In other words, he'll say, yes, precedent is such that the rule here is that we ask you to pay for repairs. However, this case can be distinguished because not only is there a broken piece of mechanical equipment, there is also going to be lost income as a result of that. Therefore, we can add additional penalties to the person who was guilty of stealing and harming the car. So, courts will follow precedent as much as they can, because that rule of what did we do in previous cases, it provides a sense of a little sense of certainty and permanence as people look at what have the courts usually been doing in these cases. But if your case is wildly different, then you may ask the court to distinguish the case because of the differences in the facts. Now, a lot of these issues came up recently in a 2019 case called Gamble versus the United States. Gamble was an individual in Alabama who was illegally possessing guns that he didn't have a right to possess. The state of Alabama prosecuted him because they have a statute making it illegal to do so, and found him guilty. The federal government also prosecuted him because the federal government has a law that also prohibits the same activity. So he got charged in criminal court twice, once at the state level and once at the federal level. So this was not a situation where we have a criminal case and a civil case against you for the same set of actions, which is perfectly fine, it happens all the time. This was someone being prosecuted in a criminal case at the state level and a criminal case at the federal level for the exact same actions. He argued this was unconstitutional because the Fifth Amendment of the Constitution says, no person shall be subject for the same offense to be put twice in jeopardy of life or limb. Okay, you can't be put twice in jeopardy for the same offense. The Supreme Court held that that did not apply to this case. And the reason, they gave two reasons. First, the criminal case in the state was the state versus Gamble, and that was one offense. The federal case was the federal government versus Gamble, and that was a different offense. And they said there were different offenses because there were different parties to the case. As I said, in criminal law, one of the parties is always a government body. And since two different government bodies were involved, these were two separate cases. But the other thing they did was they looked at judicial precedent, and they stood on stare decisis. And to do so, they went all the way back to a case from 1847. In 1847, the federal government had a law that made it illegal to help runaway slaves. This is prior to the Civil War. The state of Illinois also had a law prohibiting helping runaway slaves. Someone was prosecuted under both of those statutes. They had also argued, hey, double jeopardy clause says I shouldn't be prosecuted twice for the same offense. And the court way back in 1847 ruled, again, since you've got different parties to the case, Illinois and the federal government, that these were two different crimes, and he could be. The court then looked at 12 major decisions on this very issue over the next 170 years. And they said, look, this is what we decided in 1847. We have followed that precedent ever since. At any point along the line, all Congress needed to do was pass a law saying the federal government shall not prosecute anyone for the same set of circumstances as they are prosecuted in the state. They didn't do that. Therefore, we stand on precedent. This was a 2019 case. Gamble lost. He was convicted in both the state and the federal government. He had penalties piled on top of him from two different jurisdictions for the same crime, for the same set of facts. The decision was 7-2. There was a dissent. It was a very interesting dissent by two justices. Ruth Bader Ginsburg, who is often seen as a hero of progressively changing the law to be more modern and more applicable in a modern society, and Neil Gorsuch, who is often seen at the other end of the spectrum, who insists on looking solely at the text of the law or the text of the Constitution, and is willing to ignore or not go by stare decisis when the text is clear. And to him, the text that no person shall be subject for the same offense to be put twice in jeopardy is clear on its face. Therefore, it cannot be done. So you had Ruth Bader Ginsburg and Neil Gorsuch joining together in a dissent against this decision. But most of the judges went with stare decisis and said that, yes, he can be tried twice for the same offense because they're two different parties to the case, the state of Alabama and the state and the United States. So that was a run-through of a lot of the terms you're going to see in cases. So when you see a judge write that something is distinguished, or he's looking for standing, or looking for a causal relationship, these words in the decisions tend not to be bold-faced, underlined, italicized. There's no bells and whistles. They're simply words inserted into cases. So it's easy to miss them. It's easy to think they're just using common language just like we do every day when we're talking. But those words, substantive, procedural, criminal, civil, precedent, they all mean something very, very critical to their decision and to their reasoning in moving you through to that decision. So hopefully that was helpful. In the case we're going to be looking at this week, I've chosen a case that pulls many of these words into the case to give you an opportunity to be able to see how the judges use them to come to their conclusions. Thank you. See you next week.